let's take a look at another fairly short set of slides on bankruptcy. Now, I do want to point out as we start talking about the bankruptcy chapter that in the material that I have posted for you online in the contents for Module 6, I do have a hot link to the bankruptcy court. And one of the interesting things you're going to see is that there are a number of chapters to the bankruptcy code. We're only dealing with 7, 11, and 13, and I'm going to talk about those for the next few minutes. But there are special bankruptcy provisions for family farms. There's special bankruptcy provisions for, of all things, municipal bankruptcies. And that's a very sad commentary on the poor operation of government in the United States, that the biggest city so far to go through municipal bankruptcy is Detroit. Stockton, California, I happen to know, went through bankruptcy also. And this, like I said, a very sad commentary when you consider that these jurisdictions have the right to tax people. And unfortunately, the bankruptcy rules have been used to basically rape the public. So in the case of the Detroit bankruptcy, they defended the pension plan for the workers, but they hurt a lot of other parties that had provided money to the city of Detroit, like bondholders and people like that. So it was not a very fair resolution to the municipal bankruptcy there in Detroit. So we're going to introduce you to basics of bankruptcy. As I've mentioned earlier in the course, I think I mentioned this in the introduction to the whole course, is that unfortunately we do include, I will not use a textbook for business law that does not include a separate chapter on bankruptcy, because it is unfortunately a very serious reality. And I think we actually talked in response to a question on Tuesday that we may be seeing a lot of bankruptcies next year as the federal agreement to hold off on pursuing certain things happen. And if they do not ease up and let landlords evict people, then I think you're going to find some landlords that just cannot keep paying the mortgage, and you're going to see a sharp increase in bankruptcies and foreclosures, unfortunately. And one of the things to keep in mind is bankruptcy is a very severe thing to do. It is very damaging, and it should only be used as a last resort. And unfortunately, there was a period in time where people use bankruptcy on a more routine basis. And unfortunately, there's a lot of college students who did this, is they would get out of college, get a good job, run around, buy a new car, buy a nice house, buy a bunch of furniture and appliances, and get ready to live the good life, and then say, but you know what, I've got all this credit card debt now. I'm just going to file for bankruptcy, wipe out all the debt, and party on. And what happens in a state like Texas with the Homestead Act, not only is your house protected, but the possessions in your house are protected. So most retailers, say a Macy's or a company like that, they would not go into your house, or were not legally able to go into your house and take a TV or couch back or whatever you purchased from them. So it was a very awkward situation. So what happened is in 2005, we had the Bankruptcy Reform Act. And in that act, it said, if you are a wage earner and you're currently making money, you cannot use Chapter 7 liquidation bankruptcy. You have to use a special new chapter called Chapter 13. That's also known as the wage earner plan, which says, well, we're going to give you some time to make the payments. Now, the other part of Chapter 13 is it will be a significant ding on your FICO score and your credit, but it will not be as big a hit as if you had done a 7 liquidation. This is an important slide. This is slide 4 to Chapter 30, and this is some terminology that you need to be comfortable with. Most of us are familiar with the fact that debtor is the person who is going through the bankruptcy. Claim are the creditors to the debtor to get their bills paid. Order of relief is an acceptance of a case into the bankruptcy court. Now, that does not mean it's definitely going to stay in the bankruptcy court, because the debtor has to cooperate with the bankruptcy court. And then the discharge is when a debt has been before the bankruptcy court and ruled that the debt is now discharged. Now, in one of the, unfortunately, costs of being in bankruptcy is the trustee. If you're in a Rule 11 situation, the trustee is going to be paid. And I've seen a situation where the trustee was paid so much in a Chapter 11 that they wiped out the estate. All of the money that the estate had at the beginning of the bankruptcy went to the trustee. Nobody else got anything, which I consider a very sad outcome. So anyway, that's slide 4 for Chapter 30. So they've got several approaches here. The one that most of us think of when we hear Chapter 7 bankruptcy is liquidation. And this liquidates the debts by selling all of the property that can be sold. Perhaps one of the excellent examples of this that we've been through is Circuit City, the appliance store chain. It was similar to a Best Buy. And Circuit City, which was based in Richmond, Virginia, failed in the 2008 recession. And I had some inside views on that. It was a very interesting situation. But in any event, that's a liquidation. Everything inside the retail stores was sold. All the furniture in the office was sold, unless it was subject to a lien. It was subject to a lien that we were just talking about in Chapter 29, then the banks or finance companies that had the liens on those items, or if the stuff was in there on a PMSI, a purchase money security interest, then people could go in and take the items that they had security against. Again, this is not a friendly fight. You're going to see people down in the courthouse fighting it out as to what they maintain has liens on it and doesn't have liens on it. Most of us as business people or future business people are familiar with Chapter 11. Every major airline except JetBlue and Southwest Airlines has been through a Chapter 11 reorganization, and it's not really open to individuals. Chapter 13, on the other hand, is what we talked about, that wage earner plan. Now, again, there are 4 or 5 other types of bankruptcy, but we're not going to be dealing with them, but just to be aware of them. So I do, again, encourage you to at least spend a few minutes with the website for the U.S. bankruptcy courts. This is another excellent slide. This is slide 6 of Chapter 30, which gives you a pretty good display, a checkbox here of Chapter 7, Chapter 13, and Chapter 11. Now, one of the cases that we've touched on already, and we're back touching on it again, is, of course, the J. Howard Marshall case, where he had married the starlet and former Playboy model, Anna Nicole Smith. So what happened with Marshall is, we passed away, Anna Nicole didn't like the deal that she got because she was under a prenup and all this, and she got some money, but she didn't get a huge amount of money. So they decided to use a strategy which ultimately was not successful, and that is where they moved in bankruptcy court in California. They put Anna's estate into bankruptcy, and then attempted to get the Texas case, the domestic case in Texas, moved over to the bankruptcy court in California. That was not successful. Now, again, as I mentioned, Chapter 7 is a liquidation. It's designed to eliminate the debts of the debtor. And that doesn't mean there's enough to cover everything. It just means that's all there is, and then everything else gets written off. So one of the things we want you to look at here is the discharge. Keep in mind that you have to list the debt. Now, that has positives and negatives. The positive is you're living in a house, you don't have any place else to go. So you put everything in bankruptcy except your mortgage and your car payment, because you need a car to get to work, so you have to keep making the car payments. And you like where you live, and it's a reasonable mortgage payment. So if a lot of debt, again, is usually credit card debt, add-on debt, medical bills. So you are able to pick and choose. But if you don't list a debt in your bankruptcy, it exists after bankruptcy. You can't say, well, hey, I went bankrupt, tough luck, buddy. It's like, no, 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 no. I never got notice that I was one of the creditors. I didn't have an opportunity to present my claim. I checked the record. My claim has not been dismissed. Therefore, it is still an active claim. And you may say, well, why would somebody go through bankruptcy and not do a lot of homework, make sure they wipe out all their debts? The answer is sometimes there's personal reasons for that, but oftentimes it's just because it's overlooked. So we just talked about Chapter 11, and again, you're going to be dealing with a much more expensive and administrative process. It can cost hundreds of thousands of dollars to go through a Chapter 11 rather, corporate restructuring. Again, think about the massive big airlines. Now, one of the things we mentioned was this Chapter 13 as an alternative to Chapter 7 for wage earners. And the idea is that to give someone the opportunity to pay the debt off over a longer period of time at a lower interest rate than they would have had if they stayed where they were. But there are some significant issues with it in terms of you're only allowed to use it under certain circumstances. And one of the advantages, though, is it's basically like a debt consolidation program, which we see on television, and you may know this through your local credit union. So again, the Chapter 13 acts like a debt consolidation program to give somebody more breathing room, lower interest rates, longer period of time to pay the bills. So one of the things that we touched on before, we'll touch on again, is that in bankruptcy, there are two levels of exemption. You have to pick. You can't take both. But the federal exemptions are structured in a certain way, and the state exemptions. Now, again, in our case in Texas, the Texas Homestead Act is very generous. And so most people who are going bankrupt in Texas are going to select the state exemptions. Not everybody, but it's usually the best course for most people. Now, one of the things that we've talked about is debts that are not discharged. Child support, spousal support. And by the way, Uncle Sam, yep, Uncle Sam can come get some money because it's his turn. So it's a pretty interesting situation there. But again, a debt has to be specifically listed. And one of the problems that we see is sometimes people who have a lot of debt just lose track of certain things, do not get the message out to everybody, or they're just ignorant and they think, well, I gone bankrupt, I'm done. And if you didn't list a particular debt, then you're not done. So this is a particularly sad case where you've got a person who's only paid $755 out of $77,000 in student loans. So boy, that's a pretty good chunk there. Now, the predecessor to the 2005 Bankruptcy Reform Act was the 1978 Bankruptcy Reform Act. Now, this was the big daddy. This was an almost total restructuring of how our bankruptcy courts operate and how people utilize bankruptcy. So that is still the law of the land, subject to the amendments in 2005. So most of the time you can voluntarily commence. Involuntary commencement is usually when someone starts paying some bills. It's clear they're insolvent, but they're not paying other bills. And the people who are not getting paid rush in and say, well, wait a minute, this person's playing games. We need to go ahead and put them into bankruptcy. That's involuntary versus voluntary. So within the 2005 Act, Congress was adamant under Chapter 13, debtors should receive credit counseling. I find that fascinating. But in any event, if you're in 13, you have to have credit counseling. Now, part of the thing is, again, as part of our objective here of helping you be comfortable with the terminology of bankruptcy, is to understand a trustee is appointed over estates, usually in Chapter 7 and Chapter 11 and Chapter 13. So you can have trustees appointed by the court, or you can have a situation that we call debtor in possession, where the debtor is more involved than just something on, just something minor. But the trustee is a very important player. And again, I've seen cases where the trustee was paid all of the available cash from the estate. There was nothing left for any of the creditors. So it's not exactly the best deal in town. There are some attorneys in town who specialize in being trustees for the bankruptcy court, and they do quite well. Trustees' responsibilities are to marshal the resources, to make sure they're not wasted, to do their best they can to make sure that they're getting the full story, that there aren't other assets being hidden, and to preside over an orderly either restructuring the debt in a 13 or 11, or in a 7 to write off the debt. I'm sorry, let's see. So on preferences, this is something that's pretty interesting, and I want to make sure that y'all understand this, because this is something that has been in the news. Okay, so here's the basic idea. You're going to go bankrupt, and to get your business started, you borrowed $500,000 from your Uncle Lenny. So even though you're going down the tube, you take $200,000 out of your business and you give it to Lenny to say, look, we're really sorry we screwed you out of the $500,000, but here's $200,000 good faith money to allow you to get set up. So that's a preference if it's within 90 days of the business filing for bankruptcy. Now, in the Bernie Madoff case, what happened is he knew he was going down the toilet, and there were some pet projects and charities that he wanted to make sure got some money and took care of themselves. So what he did is in these voidable preferences, he gave money to his family, he gave money to his pet clients and stuff like that. Sadly, after he went into bankruptcy and was, of course, sentenced to prison for 150 years, it became obvious that these preferences were to some of the other similarly situated creditors. So when the trustees got involved, they said, well, wait a minute. Even though you're a nice charity and we like you people and all that, reality is we got to play by the rules. The rules require us to take that money back from you. And sadly, it closed a very worthwhile charity that could not have that much money taken back from them, which is what happened. So very sad outcome there. And then, of course, one of the big problems, one of the reasons I won't do bankruptcy today is because I can't account for fraudulent transfers, whereas attorneys handling bankruptcy cases are actually representing to the court that their party has complied with this information. So any questions on that, again, with the different terminology involved, voidable preferences, fraudulent transfers? And then we get to creditors and claims. Again, if your claim isn't on the list, it's not going to get paid. Even if your claim is on the list, it's going to go to the secured creditors first and then to other creditors later in the process. But you have a right of set off, and that is if the creditor has already received some payments from the debtor, they have to give that debtor the copy of those payments because they may not have a scale under some circumstances. So it's important to stay right on top of the situation with the creditors, make sure that they're being comprehensive in their list and being fair. And basically this is done in bracketed sets. And again, we've made some reference to this in the past where you have someone who's missing their salary. Salary is going to be a priority item. The IRS, the big Fed, the feds are going to have priority. With regard to just routine day-to-day life and how things go, you are allowed to keep paying your day-to-day bills and your employees on a day-to-day basis, although it seems to me if you had this likelihood of being in a big office building as you resolve the case, then you may not need to worry too much about the situation. But again, if you have received some payments from the deadbeat, you obviously need to give those credit for those payments to the debtor. And as I mentioned, priorities: payroll, IRS, child support, spousal support. Secured creditors come before unsecured creditors. So that's part of the reason the course is structured like this, where we talk about negotiable instruments and then secured transactions, and then boom, we're here in bankruptcy. Folks, do we have any questions on chapters 29 or 30 as we wrap up module 6? And sure, go ahead.
So when I've seen people who are in like the process of bankruptcies, because I think all the creditors get notified, they're always saying that you can't take a payment, their payment. Is there a particular reason why, like, they really just kind of hold off on doing any type of business with them?
Yes, yes. Excellent question. Thank you. What happens is that once you've gotten notice that that company is in bankruptcy, say it's a company and not individual, then you need to make the payments to the bankruptcy court trustee. Remember, we just talked about the trustee? The trustee decides where that money will be applied. We'll look at the list of priorities, and they may not distribute the money all. They may just take that money in, put it in a special trustee account, and hold that money there. So yeah, you have to be real careful about that, because if you pay the bankrupt, you may lose the money. In other words, you give the money to the bankrupt blows the money somewhere, and you don't get any credit for it because you should have given it to the bankruptcy court. Conversely, one of the things, and I think we mentioned this earlier in the course, but this is a very important point. When you've gotten notice that the folks are in bankruptcy, you need to be extremely careful what you do. Now, here's the way that works. So, for instance, and I'll mention the name of the company. I won't mention my client, but unfortunately, I represented a custom machine shop. They made some things for a particular oil field company called Ringo Drilling. Now, it's a real name. It's a real company on the, out some distance from Houston, but in the greater Metroplex area. In any event, Ringo Drilling had owed this machine shop about $15,000 for 8 or 9 months and received no payments. So I was a little upset with the client for 2 reasons. One is they shouldn't have delivered anything without getting at least half the money up front. They shouldn't even made the product until they had half the money up front. And in a lot of custom manufacturing, they get 100% of the money up front. So my client was at fault for not practicing good business practices. The second part was they sat on the darn thing for 10 or 11 months, and then they finally came to me and said, hey, we need you to send a collection letter to Ringo Drilling. They owe us 15 grand. So I send the collection letter. Immediately back comes a notice that, hey, we're in bankruptcy. Here's a copy of the bankruptcy thing. And so we went ahead and filed a routine notice with the bankruptcy court in that case. Now, the bottom line is that my guy was a late coming unsecured creditor and got nothing. What I did is for the client is I took them off billing when we got the notice from the bankruptcy court. Now, we weren't at fault in that case because the notice was sent. We had no prior notice that Ringo Drilling was in bankruptcy. Once I had that notice that Ringo was in bankruptcy, if I had sent them another demand letter, I would be in conflict with the court, and I could be cited for contempt of court, contempt of the bankruptcy court. So it's like really a big deal. Once you know that party is in bankruptcy, you can only deal with the trustee or deal with the bankrupt estate. You cannot do any self-help or any cowboy situation. There is an important exception, and that relates to this term preferences that we talked about that I talked about a few minutes ago. And that is, if you've delivered merchandise after they're in trouble, but before you knew about the bankruptcy. So, and it's usually a very short window, like 10 days. So imagine that you're a creditor to Circuit City, which went under. Again, Circuit City was similar to Best Buy. And you deliver 100 TV sets, and 2 days later, you find out that the company is in bankruptcy. You can go back to the bankruptcy court and say, we identify those 100 TVs. They were just delivered, and Circuit City was already in bankruptcy. They should have been honest with us. They should have refused that order. So you're going to send your attorney down to the bankruptcy court to say, we want those 100 TVs. They were just delivered. They should be easy to find. Here's the serial numbers. Now, here's the problem with that. Every other creditor that's in that bankruptcy is going to run down to the courthouse with their attorneys and say, well, wait a minute. We contest that. If they're going to get their 100 TVs back, we should get all our stuff back. What's happening there is they're being greedy. They're fighting with you, but it's a 50-50 shot whether you're going to be able to get those TVs back, even though the bankruptcy law is quite clear that if you deliver the merchandise and it's still distinguishable, it still can be identified shortly after the company, well, the company's insolvent, and then shortly after that, they file for bankruptcy, then you should be able to get that stuff back. But again, there's no self-help allowed, and you are going to have to go to the bankruptcy court. And again, it's never a fair fight. You may say, gee, there's a lot of companies over there that we do business with that are nice guys, etc. No nice guys in bankruptcy. So it could be a tough day. So did we cover that question for you?
Yes, sir. Thank you.
Okay, you're very welcome. Related or other questions? Any question on the midterm exam? And folks, as you know, we're wrapping up Module 6 already. So in the last 2 weeks, we've wrapped up Module 5 and Module 6. So we've only got, the course only has 10 modules. So we're kicking away. And of course, that's fitting because we're, coming up to the midterm the midterm exam, and I will look forward to seeing everybody next Tuesday. Hopefully by next Tuesday, you will have all completed the midterm exam. I do know that 2 students have already completed it because I checked the grade book shortly before we went live tonight. And with that, folks, I wish you a good evening and look forward to seeing some good grades on the midterm exam.